Hello, my name is Jose Ramon Menguechea. I am at the University of the Basque Country. I'm a professor of jurisprudence there, and also I direct the International Master in Sociology of Law at the Oñati International Institute for the Sociology of Law. I am going to intervene in the session on interdisciplinarity in social legal research and education, session 4, on Wednesday, 31st March at 9 o'clock. My intervention, my contribution is on normativity as a key to interdisciplinarity in law. So interdisciplinarity is what we're interested in the field of law. And the question is, what is our anchor to ensure interdisciplinary approaches? What is our best approach to understanding law? So my contention is that it is the concept of norm, the idea of norm, which is really the anchor, the focal issue to start building any interdisciplinary analysis, either interdisciplinary or cross-disciplinary analysis, where the disciplines are actually not just adding one on top of each other, but actually interacting and entering into feedback relationships between each other. So our understanding of legal phenomena, therefore, comes or can come from different disciplines, but they need to have a common understanding of what the legal phenomena are. And in my view, it is precisely the idea of norm, which norm or rule, which can give such a common language that the different disciplines can actually then use. So, of course, we need a concept of norm. All the disciplines will need to identify law with norms. And in that case, then, we can assume that they will have a sort of pre-interpretative understanding of what law is. And therefore, maybe part of this pre-interpretative understanding is that they all see law as part of practical reason. That is the field which discusses and deliberates on what should be done and actually proceed to doing it, deciding, deliberating and deciding on what is to be done, what should be done. Therefore, the concept of norm is very much an essential part of practical reason, in the sense that norms are guiding action, are guiding decisions as to how to act. They are frames wherein these decisions on what and how to act and when to act are taken into account. And norms are important guidelines in guiding such decisions. They provide the framework. Of course, this allows for a social norm, an understanding of norms as social norms, as it allows for a more technical understanding of laws, of norms as legal norms. In any case, once we assume that such can be the common language of all the different disciplines when dealing with the law, then we would actually need to start identifying the disciplines. So what is the object of study? So we have identified 4 steps in this sort of identification of the relevant disciplines. The first step would be to actually decide on what is the object of study, what is behind that idea of norms. And here, again, we have this clash between the social versus the legal norm. In a sense, another way to put this is what is actually the domain of law, that the different disciplines are going to be contributing to and discussing and debating. So we have a basic option here, an alternative. Either we take a very strict point of view where only normative propositions and actually the extraction of legal norms from legal sources, from authoritative legal sources, by a scientific and dogmatic methodology and by a particular community of jurists, this limited, strict, formalistic view of what the domain of law is, what norms are in the law, as compared to a much more broader notion of normativity that would include not only the normative propositions and the extraction of formal legal norms from the legal sources, but also citizens' perceptions and emotions and actors' perceptions and emotions on the law, and also, revealingly, aspirations to justice, ideas of justice that affect how citizens and popular opinion and popular culture, popular knowledge about the law influence. And so this assumes that we are either adopting a very narrow, limited and formalistic view, or a much broader view. And depending on which conception of the legal domain and the legal norms and the approaches to the legal norms we adopt, the disciplines that will be identified as cross-fertilizing each other in an interdisciplinary approach and discourse will probably be different. So the next step would then be to identify the disciplines that might have something to say about each of these issues, depending on how the law is actually understood. So if we take this strict, more restrictive view, perhaps we can identify legal dogmatics, different subjects of law, perhaps together with formal studies of language, logics, informatics, artificial intelligence, perhaps all these, strictly speaking, sciences, perhaps sciences of interpretation, hermeneutics, all these restricted approaches, which still gives a more formalizable approach, if you like, what we would probably put into expert systems. If we adopt the wider, broader view of what encompasses law, then of course we broaden to most of the social sciences and also the humanities, including history, literature studies, possibly also theology, or sociological studies of religions, and other types of dogmatic sciences. And so really our understanding of law is going to predetermine the types of disciplines that are going to be interacting. Then in the next step, only once we have identified such possible discourses, can we then identify where and in what sense they can actually contribute, what are their different questions and approaches, their different discourses that can actually help and provide an idea of how they would go about understanding and contributing to improvements on the law, how they could actually measure them, how can measure their contribution, and then perhaps then allow for a structured dialogue where all these disciplines would be actually interacting, perhaps following some sort of research program, specific questions and steps that would be followed. And finally, also, once we have identified each of the disciplines and in what way they can contribute, what sort of discourse they have been elaborating, and how they can listen to each other as well, then we can also analyze what could be the obstacles for these dialogues and these discourses cross-fertilizations to actually take place or to engage in a fruitful conversation. And here, of course, we should look at strategies of listening and strategies of silencing. You know, how do we silence contributions from other disciplines? And of course, this is much more relevant if we take a more formalistic, restrictive understanding of law, where silencing of other potential discourses is much more usual and common. And in that sense, then, we would need to identify questions of symbolic power of each of these disciplines, of intellectual capital, questions of access to resources, to research funding, to research programs, to positions in academia. All these become extremely important elements when it comes to actually analyzing what disciplines can be heard, who can speak in their name, who is going to be listening and who is going to be silencing. So these factors have to be taken into account. And this probably takes us to the final point, which is about the role of universities in all this process. Are universities enhancing this sort of communication, or are they limiting it? And if universities are not facilitating this type of interdisciplinary cross-fertilization, then what other alternatives are there to universities where such studies can be brought forward? So perhaps other forms, institutes, research institutes, platforms, more informal settings, conferences, perhaps all these alternatives, and how we can all together bring them into a common set, where fruitful contributions can be incorporated. So education in this sense is a very key factor, because if it is in universities, university education will have to be focused in order to facilitate such dialogues, and of course choosing very well what sort of domain of law we are going to be using and following. So this is my contribution to the debate on interdisciplinarity in social legal research and education. Thank you.